ATiwari, and the title of her paper is Unraveling Antitrust Leniency, an analytical study on recent effectiveness patterns. The presentation would be of 30 minutes long, and I shall be keeping the time check, and would show the black cards at 15, 5 and 2 minutes are left respectively. With this, now we begin the session. I would request Asmita to take the stage and begin with the presentation.
Good afternoon, everyone. My name is Antitrust and I am the student of LLM, specializing in corporate and business law. The title of my research paper is Unraveling Antitrust Leniency, an analytical study on recent effectiveness. Before moving into the main content of the paper, firstly, I'd like to give a brief overview of the paper, and it goes like this. The Organization for Economic Cooperation and Development (OECD) in 2023 published a background note titled "The Future of Effective Leniency Program: Advancing Detection and Deterrence of Fraud." The note revealed that the number of leniency applications in OECD jurisdictions that provided the data of complete leniency applications from 2015 to 2021, it was declining. And this data is a motivation to research over the title, where the main objective is to unravel through the effectiveness patterns of the leniency in the present context. Throughout the research, one hypothesis is maintained. Whatsoever, leniency is the only best and effective tool of detection of cartel due to certain psychoeconomic reasons. Accordingly, this paper has suggested certain ways to maintain our balance between the probability of detection through the detection of cartels through the use of the leniency program and the deterrence to prevent the cartels from happening in future. So, for the convenience of the presentation, the paper is divided. The whole presentation is divided into two sections. First shall deal with the introduction of leniency as an effective detection tool, and second shall deal with the contemporary trends of leniency, where two aspects shall be discussed. One would be the global trend and another would be the recent trend in India. Now, to go through the presentation, firstly I would like to do this quotation of the Adam Smith, classical economist, where he has presented the general tendency of the industries to cartelize against the public, to conspire against the public, or to raise the prices even when they seldomly win. So now, to define the cartel. Cartel is that arrangement which is made by the competitors among themselves to fix the price or restrict the market or limit the market to the detriment of the consumers, so as to benefit themselves in the long run. This arrangement has a basis of trust, and leniency as that tool hammers over that trust. So effective leniency programs aim to lure the competitors to break their trust and come and cooperate with the antitrust agencies and provide the information about their cartel member, and in the exchange of which they will be provided the exemption on the penalty, and their cartel members will be other cartel members who chose to remain silent over exposing their own cartel arrangement shall be exposed to the punishment under the competition law of the respective jurisdiction. So, to make understanding of the leniency program easier, here I want to give an example. There is one enemy A and another there is an enemy B. Enemy A wants to get the information of enemy B, and there is the children of enemy B. And here enemy A, what he does is he offers chocolate to the children of the enemy and asks the children, "I'll give you the chocolate if you provide any information about your parents to me." And then under condition the child provides the information to the enemy A only. Enemy A will provide chocolate to the children of the enemy B. In this whole scenario, enemy A will get the ample amount of information about the enemy B, and that information will be used against the enemy B. So enemy A is in the leniency in connection of detecting the cartel. And through this connection, a leniency in fighting against the cartel provides a legitimate forum for the cartel members to come and cheat over their own arrangement and show some kind of dishonesty over their arrangement, and compliance with which they will give exchange exemption from the penalty and keep their own cartel member on the verge of inspection by the Competition Commission of India, for example, or antitrust authorities. So when they are prone to give the substantial punishment under the respective competition law. So now, leniency, as also known as amnesty or clemency, when connected to the when it is analogous to jurisprudence, it can resemble a form of pardon. Now, how it works? By offering leniency, the authority expects, authority in the sense antitrust authority, expects to destabilize the cartels through three main actions. First, by increasing the chances of breaking of such cooperation. Second, getting into every suspicious and insider information that the members gathered and used to get benefit from their agreement. And third, preventing the formation of similar cartels in future, where it will ultimately lead to the situation where there is breaking of price war and ultimately leading the market to the competitive pricing level. So, to conclude, it effectively works through the 5 phases: detection, deterrence, sanctioning, cessation, and cooperation. So, leniency is for whom? Leniency is for the primarily for the competition law enforcement authority. Through leniency, it gives the every insider information through which it can initiate the prosecution by detecting the cartels. It is for the competitors in the market who are forced to exit the market because they could not compete with the cartel members. It is for the co-conspirators who wants to come out of the cartel arrangement and want to keep their own other cartel member in the verge of punishment from the antitrust authorities. It is for the end consumers because the overall objective of the leniency program is to prosecute and punish the cartel members. Ultimately, when there is no such cartel in future, then it will obviously benefit the end consumers, where they can get to exercise their consumer sovereignty and get desired products and services at the competitive price. And lastly, it is for the consumer welfare oriented future. How it is being used? Regarding how it is being used, I have taken the reference of India, Competition Commission Act 2002. The section 46 has provided provision on the leniency, while now there has been Competition Act 2023, where section 46, subsection 4 is added in the same provision, and this is provided about the leniency penalty plus leniency plus provision. Regarding how is it working in India, the Competition Commission of India provides 3 levels of leniency treatment. First is 100%, second 50%, and then third 30%. However, providing these all kind of treatment depends upon 4 major factors. First, the level of cooperation that the leniency applicant provides to the competition authorities. Regarding the level of cooperation, it should be genuine, continuous, expeditious, and full. The quality of the information that the leniency applicant provides, whether that information helps the CCI to detect the greatest cartel that is affecting the consumer in high volume and quantity, and whether the leniency applicant has abstained itself from involving in the same cartel again or not. So it also determines whether which form of treatment is to be leniency treatment is to be given to that particular leniency applicant, and it also depends upon the facts and circumstances of the case. However, in all these scenarios, the significance of the leniency application is until the investigation report is updated. If the leniency applicant applies for the leniency of no use. So it has to be before the investigation report is updated, and he has to provide sufficient evidence that helps the Competition Commission of India to establish the prima facie evidence of cartel in this regard. So now another section of the presentation is contemporary trends and leniency, where first trend is global trend, and thereafter it's declining leniency application as stated earlier in the background, and second is leniency inflation. So regarding the global trend, declining trend of leniency application, it looks like this. So the OECD jurisdictions have increased implementation of the leniency programs. The report from 2015 to 2021 shows that a declining number of leniency application in the OECD jurisdictions of 51 countries that has provided the complete leniency data. So the global trend of this decline is over the period of 7 years is 65%, and concerning the South Asian concerning the Asia Pacific region, the decline in application from 2015 suddenly got a spike in 2018, and it started declining till 2021. But if the data shows that the difference in declining of number of leniency application from 2020 to 21 is not of much that difference. So, and in the same line, some jurisdictions like Brazil, Italy have shown the resurgence of the leniency application. OECD in this regard has contended that this trend of declining leniency application is not the indicative of ascertaining the either success or efficacy of the overall leniency program. Rather, it is an indication for the antitrust authorities of each and every country to promptly examine their antitrust regime, and in light of their qualitative data and in-depth analysis of the case. So, while one of the concerns that is posed by the report is whether the declining data is due to increased deterrence of committing cartels. While this is the take of OECD on where it has raised the question whether the declining data is due to increased deterrence of committing cartels, there is another concept of leniency inflation which closely looks towards the deterrent impact caused due to excessive use of the leniency treatment these days. So the concept was coined by Caterina Margao and Giancarlo Spongolo in 2023 from the recent article Leniency Inflation, Cartel Damages and Criminalization, where they have studied the increasing amount of leniency treatment to penalize the cartels. It has affected the deterrence impact in the cartel enforcement mechanisms, and according to them, leniency inflation is characterized by basically two factors: excessive use of the leniency programs, or overuse or over-reliance of the program, and second is abuse of the program. So excessive use of the program is characterized by substituting the leniency program as the substitute of other investigative tools by the antitrust authorities, and providing leniency treatment rampantly to the multiple offenders, even to the recidivists. This is the concrete example that's happening in European Union right now. And leniency, even when the applicant is not the first one, the non-exhaustive leniency treatment that is provided to a number of cartel members. Differing judgments when the multiple jurisdictions is involved. And the abuse of the leniency program is contended that in this account is contended that the leniency applicant, who are mostly the multiple offenders or recidivists, they are using the leniency programs strategically as it resembles the game theory, where they involve in certain cartels and then inform about they don't want to remain in the cartel, they go and inform about the cartel complaint to the antitrust authorities and give leniency treatment, and then they, after obtaining the leniency treatment, and then again they involve in another cartel arrangement, and then again applies to this goes on, and they are strategically using the leniency treatment in their favor and keeping their members into them. So they have contended that the leniency inflation is the cause of decline effectiveness of the program and lessened deterrence, and have also argued that excessive use of the leniency creates distortion, waste of resources, and reduce the expected sanctions, ultimately undermining the deterrence. While the prior provisions were
summarize your rest of the discussion in 5 minutes.
So, another aspect of leniency, especially in context of India's settlement provision, and settlement provision based the efficacy of leniency question in India. So, whether to include the cartel into the ambit of settlement was raised in 17th Standing Committee in 2019, where the Competition Law Review Committee sought the deliberations of FICCI, Federation of Indian Chamber of Commerce and Industries, and whereas FICCI and the Standing Committee itself argued that the provision of cartels should also be included into the settlement provisions, while the Competition Law Review Committee and the Ministry of Corporate Affairs said no. They said no because the reasoning of that was cartels being the crime of pernicious nature and egregious violation of competition law. Cartels should be kept out of the ambit of the settlement provision, and already there was alternative provision on leniency under Section 46. So it was not needed to include Section 3 in the ambit of settlement provision. So this shows that India is concerned about the deterrence impact of leniency regime. And the other provision is on leniency plus, and this provision is recently added by the Competition Amendment Act 2023, and subsection 4 is added in Section 46 of the Competition Act 2002. Leniency plus is a provision which provides the leniency applicant an opportunity to expose another cartel where it has involved and which is not in the information of Competition Commission of India. And for providing that information about the cartel, another cartel where he has involved, then he will be given exempted punishment of up to 30% in the first cartel, and he may be subjected to 100% exemption from punishment in the second cartel, newly declared cartel. So this provision is expected to create a ruling effect upon the cartel members, propelling others to join the race for confession and availing the CCI the abundant information through which CCI can establish the prosecution and initiate the punishment provision. However, this provision is opposed to the penalty clause. It has been argued that until and unless the penalty regime is made stricter or limiting providing the leniency treatment to more than limited number, this expanding only the scope of leniency might not help to create sufficient deterrence. So with this, there are certain problems regarding the deterrence when leniency is concerned, and as leniency inflation has suggested, the effectiveness of the program is lessened upon is declining upon the deterrence impact, and there has been voices out for the need of criminal sanction because some of the scholars as stated here, former US Assistant Attorney General Joel Klein says the price fixtures are well respected. If the theft are criminalized, then why not the cartel members? And it should be the leniency benefit should not be that non-excessive. It should be limited to certain number of leniency applicants. It should not be excessive. And regarding the competition advocacy, as the grassroots consumers are the well-reinforced beneficiary of the of the antitrust laws. They should be well informed about their rights, their consumer sovereignty issues. And to solve these problems, it can be done like disqualification of the directors of killing enterprises, or penalizing the conspirer, increase the personal capacity, enhancing the private enforcement right, and schemes by expanding the competition advocacy programs. So clarity, certainty, and fairness are considered to be the cornerstones to make the programs effective. So it's high time that it is necessary that leniency problem is to be reviewed and enforced.